Hello everyone, welcome to our channel PH Webcan Videos. Today in this video I'm going to discuss about the provisions of Companies Act 2013 read with Secretarial Standard 2 that deals with general meetings, to know how to draft the notice of AGM and EGM, or rather what are the contents of the notice of AGM and EGM. So basically both the points are covered in the Companies Act and SS2 only, so we'll be discussing it today. And I've prepared this video on request of one of the viewers of my channel. So let us proceed and see what are the contents of notice of general meeting. So this is a very important kind of questions for the examination point of view, wherein they ask you practical question like a company wants to raise capital, authorize share capital, and because of which it has to alter its memorandum. So you have to draft a notice for calling of general meeting, and that too EGM or AGM they could specify the same. So based upon the credentials of the case study, we have to draft a notice. So in that point of view, since the students are not aware of the practical working of the corporates, so that is why maybe they could not be able to write those answers properly. So we'll be firstly discussing the theoretical aspect as to what are secretarial standards and what our Companies Act says about drafting of AGM and EGM's notice. And secondly, we'll see the actual draft of such notice. Okay, so let us proceed. So firstly, it is specified that notice shall specify the day, date, time, and full address of the venue of the meeting. Now, regarding AGM and EGM, I have already discussed in my previous videos, so I'll not be going into detail of it. Just for a brief understanding, I would say that AGM is called once in a year. Okay, and in AGM there are four businesses that are actually called as ordinary businesses, which are dealt only in AGMs. And apart from those four businesses, all other businesses are special businesses. Correct. Now, first point was this. And what are all those four businesses? It is declaration of dividend, adoption of account, retiring, appointment of any director in place of retiring director, and appointment of auditor. Okay, so these four are the ordinary businesses which are going to be dealt in only the AGMs of the company, and all other businesses are known as special businesses. Now special businesses can be dealt in AGM as well, and also where the business requires urgency and the company cannot hold its business for a year and wait till the AGM to actually pass that resolution or pass that business. So in that case, between two AGM, company could decide to call a EGM, and in that EGM, it could pass the special businesses only. So in EGM, there is no ordinary businesses that are to be conducted or transacted. Clear? So this was the first basic points, which is actually a kind of recap, which I am discussing it because just to go through the provisions of notice we need to clear the basics as well. Okay, secondly, it talks about extraordinary general meeting, wherein extraordinary general meeting can be either called by the board suo motu or by the requisitionist. Correct. So board can call it if there is so need, and requisitionist can also call the same. Now when it talks about extraordinary general meeting, then it can be held anywhere in India. Okay, but when it comes to annual general meeting, it can be held only at the registered office or in the city town where the registered office is situated. Clear? But the EGM that is called upon by the requisitionist, that is also to be held in the registered office or the city where the registered office is situated. So these are the basic points. I'm not going into much details. What are the bifurcation of them? But once you draft the notice for any case study that comes into your exam, you have to be clear with those conceptual things. Okay, otherwise your basic points would be wrong and there would be the possibility that you could deduct your marks, or examiner would not give you full marks. Okay, so in those scenario, You have to be very much clear with your concepts with regard to AGM, EGM, calling of EGM, AGM, and everything which you are actually putting in. So now, first of all, as I said, the contents of the notice of EGM and AGM, that is the general meeting, is that notice shall specify the day, date, time, and full address of the venue. Now, suppose if you don't know that the annual general meeting are to be called only at the registered office or the same city where the registered office is situated, maybe you could call the full address. What you will define in the draft notice, maybe it's something different because your concepts are not clear. Just I'm taking an example. So in that case, examiner will give 0. Okay, for that portion, because he is only judging you with the concepts. By giving a case study like this, he is actually testing you upon the concepts as well as your practical knowledge. Okay, so now what if the date and day are mismatched? Like suppose if there is if it on that day it is date it is Tuesday and you have written Wednesday. So in that case, technically I'm talking, legally I'm talking here, not from the examiner's point of view. I'm talking that technically the validity of notice would be at danger, okay, and it would be known as the bad at the eyes of law. Clear? So one thing has to be kept in mind, that where malified intention is proved easily, then in that case your notice will be called as illegal or it would not be considered as valid. And the onus of proving whether your contention was malified or bona fide is upon the company only. So it's better not to take that risk and indulge into the litigation. It's better all these things are described actually and clearly, so that there is no option of getting into the litigation or getting into the actual discussion of whether you are right or you are not. Clear? So day, date, time, and full address and of the venue of the meeting has to be disclosed. Secondly, notice shall clearly specify the nature of the meeting. Okay, and the businesses to be transacted thereat. So once we don't know the businesses, that is at annual general meeting only you can discuss ordinary businesses as well as the special businesses if the case arises, but ordinary businesses cannot be dealt where? In the EGM. Then if there is no clarity in this, errors are bound to happen. Okay, then another point is, suppose if there is any special businesses as it is transacted, then in that case along with the notice, what else you have to annex? You have to annex explanatory statement that will explain the businesses that you are transacting at your general meetings. Okay, but this is only in case of special businesses. Clear? And this explanatory statement provision is given under section 102 of the Companies Act, where the basic intent is to clarify your actual rationale behind passing that resolution or to be passed by the members. Okay. Now, if there is an ordinary business, then in that case resolutions or notice do not need to annex any explanatory statement, except for the case where auditor or directors are appointed apart from the retiring auditor or director. Okay, so in that case only you need to explain the you need to give the explanatory statement, otherwise there is no requirement. Now, matters to be contained in the explanatory statement. Now, what all you have to give it in explanatory statement? First of all, as the name itself suggests, explanatory statement, which means explanation given for the businesses that are proposed to be transacted at the meeting. Clear? So, first of all, you have to give that. Secondly, you have to disclose what is the nature of concern or interest, whether it is financial or otherwise, of in the business which is going to be transacted. Okay, of the director and manager and other key managerial personnel and relatives of the persons mentioned above, that is relatives of directors, manager or KMPs. Clear? You have to basically disclose that what is the nature of interest, if there is any, of these persons with respect to the resolution that is proposed to be passed in the meeting. Clear? And if there is no such interest, then you simply have to say that none of the directors or KMP or their relatives are actually concerned or interested in the business that is going to be transacted in the aforesaid meeting. Okay, so Another thing it says, which is very important, that material facts with regard to the concern and interest, and apart from these also, you do not, the company has to actually not give these based upon the records. Okay, so apart from the records, it is actually have to make certain inquiries with respect to that, so that no interest or no concern gets missed out. Okay, you have not to be totally dependent upon the records prepared. Okay, you have to give a extra inquiry towards it, and you should understand the nature of such interest and concern of any director or KMP. So this is the point which the company has to think, okay, while giving this statement, whether the directors or KMP are having any interest in the business proposed or not. So in that case, it does not have to depend upon the records made upon. It will definitely depend upon those records, but apart from them, that certain inquiry is also required to be made so as to know the actual nature, so that nothing is hidden. Okay, the only thing that is the rationale behind this explanatory statement and this disclosure is simply that the members should know whether there is any hidden advantage to the director or KMP or relatives of them, because members are not directly dealing in with the affairs of the company. So there should be a transparency. Okay, so this is the basic intent of this explanatory statement. Now, moving on. Notice and accompanying documents have to be given at least 21 clear days. This we are reading it from since the beginning of our company law. Okay, so notice and all the documents along with that, it has to be given 21 clear days before, in advance of the meeting. So, and what are the accompanying documents? I'll be discussing it in next slides. Secondly, it says that 21 clear days simply means that date of serving of notice and date of the meeting have to be excluded. Okay, that is why this clear days is mentioned here. Secondly, in between the notice, if there is any holidays, then that period is also counted for the purpose of counting the period of notice. Okay. Further, if suppose the notice is given by post and courier, then additional 2 days have to be provided. So first of all, date of service of notice and date of meeting are excluded. So how many days it become? 23 days. Secondly, 2 days extra because of notice by post or courier you have to give. So 25 days. So on a safer end, companies actually give 25-26 days prior this notice for the general meeting. Okay, and one more thing, because post and courier, we normally generalize that within 48 hours of posting this thing or making the courier, after 48 days, it is assumed that it has reached the person to whom that notice was addressed. Clear? Now, notice and accompanying documents may be given at a shorter period as well. However, the consent is required, and consent should be not less than of 95% of members entitled to vote at such meeting. Correct. So here we are talking about, first of all, 95% is of the members and not of the share capital held by the members. Okay, so this is in numbers. Secondly, of those members who are entitled to vote, and not of those members who are entitled to vote and who are present at the meeting. So in a case the company has called any shorter notice for called any meeting at a shorter notice, then in that case, if the members who are present and they have given the consent, would not be sufficient. Why? Because 95% of the total members who are entitled to vote, and not only those who are entitled to vote and are present. Clear? So the consent of these many members are required to be taken by the company, and it will actually give this it will actually ask this consent in with the notice only. Okay, so while giving the notice, it will ask for the consent also for the shorter notice, and if before the meeting the consent comes of this minimum 95% of members entitled to vote, then only that meeting would be convened. Clear? Now, another important part of the notice is notes, which are very important. Now, what would notes to this meeting, what would they suggest? Notes to this notice, sorry. It would be like giving the information about the proxy, that you are entitled to appoint proxy and you have to intimate at least 48 hours before the meeting. Okay, And secondly, you can mention about the explanatory statement that is annexed. You can ask for the shorter notice consent. You can tell about the closure of the register of members. Okay, you can also tell about the dividend which if declared would be given in within 30 days and all. So all these points have to be included in your notice, which are relevant of course to your company. So it varies from company to company. Okay, but proxies and explanatory statements point is obviously to be given. Okay, now moving further, what all are the annexed documents with the notice of the meeting? So first of all, explanatory statement to the notice, but only in the case of special businesses. Proxy forms are to be attached. Attendance slip is to be attached. Request for consenting to shorter notice is to be asked for with this notice only, as I mentioned again. Now, supporting documents like AOA, MOA in connection with the agenda items of the notice. Why is this being given? For, like, suppose if there is any alteration of authorized capital, then because of that MOA would be altered. So now if MOA would be altered, then members have the right to inspect that MOA. So it has to be given along with it that these are the changes that would be reflected in the MOA. Okay, and even in the explanatory statement, you have to disclose that this document is available for inspection during the business hours at the registered office or at the corporate office or wherever you have to mention. So these are the requirements. Okay, and that will again depend upon section to section as to which business you are dealing, because certain specific provisions are given for specific resolutions. Like suppose for the issue of share capital, if we say increasing of paid up share capital, then in that case it's rules itself prescribe certain things that are to be disclosed in the explanatory statement while increasing the equity share capital or the preference share capital. Okay, so you have to again refer that business also. But as far as examination point of view is concerned, you have to be really focused on what are the concepts and what are the basic things that you have to include, because you do not, at that point you would not be knowing about the company's details, so you cannot actually bifurcate it in that sense. They are just judging you upon the concepts and the practical aspects. Clear? Now I'll be discussing about the draft of the notice of extraordinary general meeting. Okay, similar would be in the case of annual general meeting, almost similar, apart from the thing that in AGM, four ordinary businesses are also to be mentioned. Apart from them, everything would be similar. Now, first of all, this notice is to be given in the letterhead, on the letterhead of the company. Clear? Then it is to be written like this: notice is hereby given that an EGM of shareholders of the whatever the name of the company is will be held on day, date, time, venue, which was the first point of our topic. Clear? Then again there is certain thing which I have mentioned it here, which is talking about the number. So number of EGM is to be mentioned. Here the important point to be noted is, in case of annual general meeting, it has to be consecutively numbered. Clear? Like first AGM, second AGM, third AGM, fourth AGM, fifth AGM. Clear? But in case of EGM, you can write it in brackets, like it is the first EGM for 2017, like it is the third EGM for 2017. But in case of AGM, you have to write that it's the first AGM of the company, it's the fourth AGM of the company, 192nd AGM of the company, whatever the case may be. Clear? Now, special business, what I said, that you have to disclose what kind of business you are transacting at that meeting. So now, since it is of extraordinary general meeting, there could not be any ordinary business here. So it is a special business. Then you have to mention the item number. Then what is the actual heading of that resolution that is required to be passed? Then this line is very important: to consider and if thought fit to pass with or without the modification the following resolution as ordinary resolution. Now whether the resolution is ordinary resolution or a special resolution would again depend upon the respective section. So here if I am talking about the amendment of memorandum of association, then you would say it would be special resolution. But I am amending this I am taking up this draft as amendment of MOA pursuant to the increase in authorized capital, then in that case it would become the ordinary resolution. Clear? Then there would be the body of resolution, like the same way you draft the resolutions, resolve that pursuant to so and so section of the act, the authorized share capital of the company is increased from this to this, and pursuant to which the memorandum of association would be altered, and this new clause, which whatever is mentioned here, new clause would be substituted in place of the earlier clause. So you have to basically disclose this in the body of the resolution, as you do in all other cases. Clear? Then again at the end you have to mention for and on behalf of the name of the company, director and director's address, the designation you have to mention. If there is any company secretary who is signing, then again these things will change accordingly. Date and place are required to be disclosed. Clear? Then these are the notes to the notice which I mentioned about. You have to disclose about the proxies, you have to disclose about the explanatory statement under section 102. Okay. Then comes the important point. Since it was a special business, the important point is that you have to give an explanatory statement. So it has to state that explanatory statement as is required under section 102. It set out all the material facts. So now first of all you have to give the reason of passing the resolution. That why are you increasing the authorized share capital? So there could be reason that company needs to increase its fund base, and or it wants to issue with preference share capital which was not there in the authorized share capital, so that is why it is increasing this authorized share capital so as to allot preference shares in future. Clear? Because you cannot increase the paid up share capital more than the authorized share capital. So first of all, if you want to increase your paid up share capital, you have to increase your authorized share capital. So maybe this could be one reason, that there is for the funding process, or you can say that board foresees that it would be requiring funds in later date. So that is why for that thing it is increasing its authorized share capital. Okay, so that in future it can increase its paid up share capital. So these are all the reasons. Like suppose if it says about name change, so it could say that the businesses which the company is doing would be more suitable with this name, and it would actually encourage, or it could actually be efficient enough to keep this name rather than the earlier name. Okay, so that is why board have already approved, and it asks your consent to approve it. Your means members. Clear? So this is all the reasoning. Here you have to mention it in very simple terms so that members could understand. Okay, because the concept is to disclose the material facts. Now, another important point which I've already discussed is about the disclosure of interest or concern of the director KMP relatives. So if no one is no one is interested like that way, so you have to write none of the directors KMP relatives are in any way interested in the said resolution. Clear? Again, important point, if the relevant document in our respect it is MOA. So if this MOA it is available for inspection during the working hours at the registered office of the company, then you have to mention that the director recommend this resolution for the approval of the member as ordinary or a special resolution as the case may be. Clear? Now after this also again the same thing would be there for and on behalf of the board of directors, name of the company and whoever is signing the details of them, and date and place also. So this is the case wherein for the EGM, the only thing that would change for AGM is that before this special businesses, ordinary businesses will take place, for which you do not need to mention the explanatory statement. Clear? And second important change is about the consecutive number of the meeting. Okay, and again, explanatory statement number should correspond to the business for which it is given. Like if in case of AGM, explanatory statement is to be given for the special businesses that comes in the notice at point number 5, then in that case, explanatory statement should also deal with item number 5, so that there could be a relation. Okay, you cannot again number like 1, 2, 3. Am I clear? So this is all about the notice of EGM and AGM and how you draft it, and for the examination point of view also, and as for the practical aspects as well. So I hope you have liked this video, and if yes, then please like and subscribe. My YouTube channel is PH Webgyan Videos. Do not forget to share and comment on this video, as your comments are valuable, so please do. Thank you.